When Justice Amy Coney Barrett summoned Senator John Kennedy to a federal hearing, it wasn't about justice, it was about power. But what she didn't expect was that Kennedy would walk into that courtroom not to defend himself, but to expose her. What unfolded next wasn't a hearing, it was a reckoning. And by the time the camera stopped rolling, it wasn't Senator Kennedy answering questions, it was Barrett facing the backlash. This is the story they never wanted you to hear. You're being summoned not for what you've done, but for what you dared to say. That line, printed in ink too bold for coincidence, was tucked halfway down the third page of the subpoena. Senator John Kennedy read it twice, then a third time. It wasn't official language, it wasn't legalese, it was a message. And whoever wrote it didn't bother hiding what this really was. The envelope had arrived that morning in a plain manila sleeve, sealed with the golden crest of the federal judiciary. The delivery had been quiet, no press, no calls, just a knock, a nod, and a signature. Kennedy might have brushed it off as another hearing request, until he saw the name. Presiding the Honorable Justice Amy Coney Barrett. That wasn't routine. It wasn't constitutional either. Supreme Court justices didn't chair federal hearings. Not like this, not involving active legislators, and especially not with a tone that felt more like a trap than a summons. Kennedy sat back in his office chair, his eyes narrowing. The timing wasn't subtle. Just 3 days earlier, his proposed Judicial Accountability Act, a bill calling for mandatory transparency in judicial lobbying and conflicts of interest, had been quietly stalled in committee. No explanation, no press statement, just a dead silence thick enough to drown in. And now this. He leaned forward, rereading the subpoena's phrasing. Testimony required. Matter of oversight. Possible obstruction. He chuckled, not because it was funny, but because it wasn't surprising. There had always been tension between him and Barrett. Ever since that confirmation hearing in 2020, when he, against party alignment and with his usual drawl wrapped in steel, questioned whether she had the independence or the humility to interpret law without bending to ideology. That clip had gone viral, her expression tight-lipped, unblinking, had said more than her answers. And now, 4 years later, her silence had taken the shape of a subpoena. The line wasn't blurred anymore. It was crossed. Kennedy reached for his phone, dialing an old contact, a former federal judge turned constitutional advisor. They finally came for me, he said flatly. There was a pause on the line. They use her, the man asked. Front and center. They're not hiding it then. This isn't procedure. It's performance. Kennedy didn't respond. He didn't need to. The whole thing reeked of retaliation dressed in robes. A move not just to question him, but to make an example out of him. To remind everyone watching that there were lines you didn't cross, questions you didn't ask, and names you didn't say aloud unless you wanted the ceiling to fall. But he wasn't afraid of ceilings. Just then, his assistant knocked, holding a folder. You should see this, she said, voice low. He opened it. Inside were screenshots, an anonymous tip, forwarded to his office inbox from a protected source. A single sentence, typed and unsigned. This isn't oversight, it's retribution. Beneath it, an attachment, a copy of internal memos, circulating within the Judicial Ethics Review Board, marked confidential. The subject line read, Pre-coordination with external counsel re-Kennedy hearing. That was it. Not a smoking gun, but the smell of smoke was already thick in the room. Kennedy stood slowly, walking to the window of his office overlooking the Capitol. The sun was just beginning to rise, casting long shadows down the marble steps. For a moment, he was quiet. He thought about what this really was. Not an investigation, not a legal process. It was theater, but if they wanted a performance, they'd chosen the wrong lead. He turned to his team. Tell them I'll be there, he said, but I'm not bringing a defense. I'm bringing a spotlight. Nobody spoke for a beat. Then his chief of staff nodded. Message received. And as Kennedy sat back down, flipping the subpoena shut with a dry rustle, his jaw tightened, not with fear, but with something sharper. Resolve. Because if the game was power, and the stage was justice, He knew one thing better than most. The moment you force silence is the moment the country leans in to listen. The courtroom was colder than expected, not in temperature, but in tone. The kind of chill that didn't come from air vents but from intentions sharpened long before anyone took their seats. Senator John Kennedy walked in with the same gait he always had measured, deliberate, unimpressed, no entourage, no theatrics, just a navy blue suit, a steady look, and the air of a man who knew the weight of silence better than most. Reporters craned their necks behind the glass as the gallery settled. This wasn't a trial. Not officially, but it felt like one. The lights were too bright, the microphones too sharp, and in the center of it all, elevated on the bench, Justice Amy Coney Barrett presided with the kind of stillness that dared someone to move first. She didn't look at Kennedy as he took his seat. Her eyes were on the file in front of her, pages she'd likely read 20 times but flipped through now just for the rhythm of control. "We are convened today to evaluate possible obstruction by a sitting member of Congress," she began, voice even. "This is a matter of judicial integrity and legislative overreach. The witness will respond directly and without deviation." Kennedy didn't blink. The prosecutor began with procedural pleasantries, the kind of questions designed to lull before the pivot. Kennedy answered plainly, name, role, timeline, and then the question shifted. "Senator, in your proposed legislation," the prosecutor said, "you implied that members of the judiciary may be influenced by undisclosed relationships. Do you believe that applies to this court?" Kennedy tilted his head slightly, just enough to register the game being played. "I believe sunlight never damaged an honest man's reputation," he said, "if that bothers the bench. Maybe the question isn't the bill, but what it reveals." Barrett's pen tapped once, then twice. "Senator," she said, "you are instructed to answer without editorializing. This forum is not for political theater. With all due respect, Justice," Kennedy replied, voice calm but flint-edged. When a question becomes offensive only after it's asked, it says more about the person hearing it than the one speaking. The room paused. It wasn't a loud line, but it cut. Barrett's eyes lifted from the folder. This time, they met his. "Senator Kennedy," she said slowly, "you will refrain from veiled accusations, or I will exercise my constitutional authority to enforce order." He gave the faintest nod, not agreement, acknowledgement. The prosecutor continued. "Do you admit that your public commentary has eroded public confidence in this court?" "No." Kennedy said, "I admit that public confidence erodes when courts act in ways that beg to be questioned." The tension grew by millimeters. No shouting, no grand gestures, just two forces pressing against each other in a room where everyone was pretending the walls wouldn't crack. Barrett sat back slightly, fingers steepled. "Senator, are you asserting this court has behaved improperly?" "I'm asserting that questions deserve answers," he said, "and if the presence of a question makes someone uncomfortable, maybe it's not the question that's the problem." Another pause. A reporter outside mouthed the words. A producer whispered into a headset. Somewhere, a red recording light burned brighter. Barrett's voice cooled. "One more disruption, and I will move to hold you in contempt." Kennedy leaned forward slightly. "You're mistaking disagreement for disorder," he said, "and if this court sees dissent as defiance, then the problem isn't the speaker, it's the standard." The room seemed to contract. Barrett said nothing. Instead, she looked to the prosecutor. "You may proceed." Kennedy sat back, hands folded loosely in front of him. He wasn't rattled. He wasn't on edge. But everyone watching could feel it, that invisible thread stretched tight between them. He had drawn the line, and she had marked it. The hearing was far from over, but the real trial, the one unfolding in public perception, had just begun. The screen lit up without warning. A clip, dated 3 years ago, filled the courtroom monitors. Senator Kennedy's voice echoed clear, unwavering, laced with the drawl that had made him a fixture on Capitol Hill. The words were unmistakable. "When judges forget that their robes are not shields for ideology, but responsibilities for impartiality, The court becomes a stage and justice a performance. The prosecutor paused the video, then turned to face the room. "Senator," he said, tone sharpened, "do you stand by that statement?" Kennedy didn't shift, didn't blink. Every word, even now, while seated before a justice of the Supreme Court. Especially now. There was a ripple in the gallery, not gasps, just movement, eyebrows raised, hands scribbling faster, phones clutched tighter behind soundproof glass. Barrett leaned forward, not to speak, but to let the silence weigh heavier. The prosecutor stepped closer. "And would you agree that statements like these, from a sitting senator, contribute to public distrust in the judiciary?" Kennedy looked directly at him. "I'd agree that silence in the face of politicized jurisprudence contributes more." The prosecutor opened his mouth, but Kennedy raised a hand, slow, deliberate. "If we're playing tapes," he said, "then let's not skip chapters." He reached into a folder beside him, pulling out a single page. He held it up, not grandly, not dramatically, just high enough that the seal was visible. "This is a letter I submitted to the Senate Judiciary Committee in 2000. See it? It questioned whether a then nominee to the Supreme Court had demonstrated the independence required of the office. That nominee," he added, turning to Barrett, "was you?" Barrett's expression didn't change, but her posture did, subtly, a shift in shoulder tension, a flicker in the corner of the eye. Kennedy continued, "Now that same justice, once questioned on impartiality, is sitting in judgment of the very man who asked that question. If that isn't a conflict of interest, I'm not sure what is." Barrett spoke then, quietly, too quietly. "You're implying I lack the neutrality required to oversee this hearing." "I'm not implying anything," Kennedy replied. "I'm stating that your presence here, in this role, after that history, raises questions no courtroom should be afraid to ask." The silence that followed wasn't awkward. It was thick, pregnant with the understanding that something had shifted. Barrett's fingers closed around the gavel. "Senator," she said, her voice colder than before, "you are not permitted to question the integrity of this bench." "With all due respect," Kennedy said, "I'm not questioning the bench. I'm questioning why the ones seated on it insist on trying a witness with whom she has a known political history." Barrett raised the gavel. "For the record," she said, "this court does not tolerate personal attacks on its officers." "Then perhaps," Kennedy replied calmly, "this court should reconsider whether its officers are acting personally." The gavel slammed down, hard. Once, twice, then a third time, faster than protocol allowed. Barrett's voice rose not to shout, but to reassert. "This court will maintain order." For the first time, the room felt unstable. Not because of Kennedy's words, but because of Barrett's reaction. Her precision had slipped. The rhythm of control had cracked. And everyone noticed. The prosecutor shifted uncomfortably. Aides at the back exchanged glances. The bailiff straightened, just slightly, sensing the temperature shift in the room. Kennedy sat still, not smug, just present, grounded. He had done something more dangerous than raise his voice. He had drawn a line between criticism and truth, and Barrett, in trying to silence it, had made it real. The monitors went black again, the lights hummed low, and for a full 10 seconds, no one moved. Because now it wasn't just a question of law. It was a question of legitimacy, and the courtroom knew it. The fourth day began, without ceremony. No announcements, no new filings, just the weight of everything that hadn't been said yet pressing down on the courthouse walls. Senator Kennedy walked into the room with the same unflinching pace. But this time, something was different, not in his posture, not in his expression, but in what he carried. A single folded printout. No folders, no binders, just one page, printed in black and white, its corners worn from being held too tightly for too long. The session resumed, and Justice Barrett wasted no time. Her voice was clipped, her gaze mechanical, the pretense of neutrality hung by a thread. "We will now return to the line of questioning related to judicial interference," she said. "Senator Kennedy, you may respond." Kennedy didn't look at the prosecutor. He didn't glance at the cameras. His eyes went straight to Barrett. "There's a difference," he said quietly, "between interference and exposure, and I think it's time we stop pretending not to know which one this is." He unfolded the paper, held it in both hands like something sacred, and began to read. "This document," he said, "was leaked to my office late last night. It's an internal email, dated 3 weeks ago, sent from the office of the Chief Counsel to the Ethics Review Division of the Supreme Court." Barrett stiffened. The prosecutor shifted uneasily. Kennedy kept going. "It references a request initiated directly by a sitting justice, urging that a targeted review be opened on Senator John Kennedy for his persistent undermining of judicial authority in the public domain." The email doesn't name names, but it does reference prior Senate testimony, dating back to 20, testimony involving you, Justice Barrett. A low murmur passed through the gallery. Kennedy didn't raise his voice. He didn't need to. "I don't care who wrote the memo," he continued. "I care why it exists. And more importantly, why the person now presiding over this hearing is the very person whose name echoes through every footnote of that document." Barrett leaned forward slightly. "Senator Kennedy," she said, measured, "this court does not recognize anonymous materials lacking verified provenance." Kennedy nodded slowly. "That's fine," he said. "Then don't recognize it. Just hear it." He lowered the page slightly. "Because I don't need a stamp or a seal to know when something's true. Sometimes the truth arrives without credentials, just consequences." Barrett's fingers reached for the gavel, but not yet. Kennedy looked at her then, really looked. "I didn't come here to accuse," he said. "I came here to answer. But it's become painfully clear this was never about testimony. It was about punishment. It was about reminding anyone who dares to question power that there will be a cost." Barrett finally spoke. "This line of commentary is inadmissible," she said, more force in her tone now. "Strike it from the record." Kennedy didn't flinch. "You can strike it from the record," he said. "You can burn the transcript, erase the footage, even lock the doors. But the truth, it doesn't ask for permission." Her voice rose. "This is your final warning, Senator." He stepped back, page still in hand. "Lies demand silence," he said. "Truth doesn't mind the noise." And then it happened. Somewhere in the gallery, a red light blinked to life. Then another. News outlets that had been denied live access began airing the leaked feed. A producer at a local affiliate had quietly patched into a backup stream unfiltered, unedited. It wasn't a mistake. It was a moment. The feed was live. Kennedy didn't know it. Barrett didn't either. But the nation did. People watched across time zones as Kennedy stood there, calm and unshaken, while Barrett's voice cracked through the silence. "This courtroom will not be hijacked for political theater." Kennedy looked at her, and for the first time, the weight of what he was holding seemed less like paper and more like a mirror. "This isn't theater," he said. "This is a reckoning, and you don't get to script how it ends." Barrett's hand slammed the gavel down. The echo was sharp, uncontrolled, not the rhythm of order but the reflex of anger. Her other hand trembled. A slight shake, just enough for the room to notice, enough for the country to replay. Over and over. She reached for composure, but it had already slipped, and in that moment the image was complete. A senator, steady, a justice, shaking, and a truth too loud to unhear. The prosecutor tried to interject, but no one was listening, not to him, not to the gavel, only to the sound of something long protected finally cracking open. Outside the courthouse, news anchors were already reacting in real time. Commentators leaned in, whispering words like conflict of interest and breach of impartiality. Viewers texted, posted, clipped, some cried, others clenched fists. But all watched. Kennedy slowly folded the page again, placed it in his jacket pocket, and sat down without another word. Barrett didn't call recess. She didn't call for order. She didn't call anything, because there was nothing left to say that wouldn't echo louder than intended. That day would become a timestamp, not just in court documents, but in memory. A single frame, the moment power met proof and flinched. The clip was only 38 seconds long. No dramatic music, no edits, just a static shot of Senator Kennedy standing still as Justice Barrett struck her gavel, and her hand visibly shook. His voice, calm and steady, repeated in loops across every platform. Lies demand silence. Truth doesn't mind the noise. By mid-morning, the hashtag #LetKennedyQuestion had begun to trend not just in political circles, but everywhere. From high school debate forums to veterans chat groups, from law professors to nurses on night shifts. People weren't just reposting the clip, they were narrating what it meant. It wasn't about Kennedy anymore. It was about something deeper, something older. The feeling that power, when cornered, doesn't correct itself, it retaliates. News outlets scrambled. Cable anchors who had previously dismissed the hearing as procedural fluff now called it historic. A few dared to say the quiet part aloud. This wasn't about order, it was about obedience. And Kennedy had refused to kneel, but it wasn't the pundits that made the moment stick. It was the woman from Des Moines. Her letter was posted online by a local journalist, handwritten in neat cursive on lined notebook paper. No legal jargon, no hashtags, just a story. I remember the day Senator Kennedy called the courthouse. My daughter had been denied the right to testify on her own behalf during a custody hearing. The judge said she was too young. Senator Kennedy didn't know me, but he knew the law, and he knew that sometimes a child's voice matters more than a rule book. Because of him, my daughter was heard, and because of that, she still lives with me today. I don't care about politics, but I care about people who speak when it's easier to be quiet. I support him today for the same reason I thanked him then. He listened. The letter was shared nearly 1 million times in 12 hours. Not because it was dramatic, because it was undeniable. Other stories followed. A veteran who said Kennedy fought to get his benefits reinstated after being wrongly disqualified. A civil liberties attorney who admitted they'd often disagreed with Kennedy politically, but said, "When I watched that footage, I didn't see a Republican. I saw someone refusing to be silenced under pressure. And if we lose that, we lose everything." Even within the judiciary, cracks began to show. 2 retired federal judges released a joint statement calling Justice Barrett's conduct deeply troubling and a departure from the standards of judicial temperament. They didn't mention the email. They didn't need to. Everyone had seen it now. Then came the clip that broke through even the partisan noise. A member of Congress from the opposing party, a man who had publicly sparred with Kennedy for years, appeared on national television. He looked tired. He didn't smile. He spoke simply. "I never thought I'd say this, but when I watched that hearing and saw the way the senator was treated, I felt something I hadn't felt in a long time: shame. Because if the last person speaking truth in that room was the one I usually vote against, then maybe this isn't about sides anymore. Maybe it's about survival. And maybe, just maybe, the person I've called my political enemy for years is the last man reminding us what this democracy is supposed to sound like." It wasn't a concession. It was a confession. And it echoed. By nightfall, the phrase had made its way into headlines. Not enemy, conscience. Kennedy hadn't spoken since the hearing ended. No press conference, no tweets, just silence. But in that silence, something else had begun. A shift. Not in power. In clarity, it started with a silence. Not the calm kind, but the uneasy one, the kind that comes just before a secret breaks loose. A security technician at the federal courthouse had flagged a video anomaly. Nothing dramatic, just an extra hour of camera footage that hadn't been cataloged like the rest. It showed a conference room, dull walls, fluorescent lights, a place designed to be invisible. In the video, Justice Amy Coney Barrett sat across from the lead prosecutor. No court reporter, no clerks, just the 2 of them, and a yellow legal pad sitting squarely in the center of the table. They weren't reviewing evidence. They were rehearsing. Barrett spoke first, calmly, intently. "If he brings up the 2020 letter," she said, "we pivot to decorum, frame it as a breakdown in professional conduct." The prosecutor nodded, scribbling notes. "And if he questions jurisdiction, we redirect it to Emphasize institutional trust. Do not engage on legality, just control. The footage was time-stamped 48 hours before Kennedy ever set foot in the courtroom. It took less than 2 hours for the clip to leak. No dramatic headlines, just a quiet post on an anonymous legal watchdog forum. But the fire spread anyway. By noon, it had crossed into mainstream outlets. A side-by-side edit aired on primetime cable Barrett, rehearsing the very lines she later used to silence Kennedy. Her language wasn't accidental. It was scripted. And then came the resignation. Sophia Lantham, a senior advisor to Barrett for over a decade, submitted her resignation in a single-page letter that went viral within minutes. I can no longer, in good conscience, participate in a process that has abandoned neutrality in favor of coordinated retaliation. The actions I have witnessed violate not only precedent, but principle. She left the courthouse carrying nothing but a manila folder and her own dignity. Reporters were waiting. She said nothing. She didn't need to. Her letter was now public record. The Judicial Ethics Board convened an emergency session the next morning. Their statement was brief but damning. We are launching a formal inquiry into allegations of improper coordination and potential ethical violations regarding Justice Amy Coney Barrett's conduct in the matter concerning Senator John Kennedy. Barrett was instructed to recuse herself from all proceedings related to the hearing, effective immediately. She did not appear in court that day. No robe, no bench, no gavel, only an empty chair where power once sat unquestioned. In its place stood a substitute federal judge, soft-spoken and visibly cautious. Kennedy arrived, as always, without fanfare. He took his seat and said nothing. The courtroom was quieter now. Not out of fear, but out of respect. The kind reserved for someone who had absorbed every attack without flinching and still refused to gloat when the tide turned. Outside, a crowd had gathered. Not a mob, not a protest, just people. Some held signs, others just stood, watching the building that had, for a moment, stopped being a place of procedure and become something else, a mirror. A place where systems either reflect justice or distort it. Inside, the new judge addressed the room. We will pause proceedings pending the outcome of the ethics inquiry. No one objected. Kennedy nodded once. He didn't speak to reporters as he left. But one microphone caught a quiet exchange as he passed a young law clerk in the hallway. The clerk, barely 25, whispered without thinking. "Sir, thank you for not blinking." Kennedy glanced back. "Son," he said, "when truth's on the line, blinking's not an option." Then he walked on. Not as a senator defending his name, but as a man who refused to let silence win. And now, for the first time, the system would have to decide, not whether he had gone too far, but whether it had been raining for hours, not a storm, not the violent kind that knocks down power lines and floods streets. This was the steady kind, the kind that falls softly, insistently, as if the sky itself is mourning something it doesn't have the words for. Senator John Kennedy stepped onto the courthouse steps without an umbrella. He wore no overcoat, just his usual suit, slightly wrinkled, darkened now by rain that soaked through fabric like truth, through pretense. Reporters stood in clusters under canopies, staffers whispered into phones, but Kennedy didn't rush. He didn't wave. He walked until he reached the podium, then stopped and looked out not at the cameras, but at the people behind them. No prepared speech, no teleprompters, just a folded copy of the Constitution in one hand and something heavier in the other conviction. He waited a moment, let the rain speak first. Then he began, "When I was a younger man," he said, voice low and clear, "I once stood in a different courtroom, not as a witness, not as a senator, just as a citizen." He glanced toward the marble steps behind him. There was a bill on the floor that would have limited public access to certain government hearings. I opposed it, not because I agreed with everyone who might show up and speak, but because I believed they had the right to. He paused. There was a man I disagreed with, loudly, repeatedly. He and I shared almost nothing in terms of views, but I fought for his right to speak in that chamber. And when someone asked me why I defended him so fiercely, I told them the truth. He looked straight at the cameras now. It wasn't because he was right. It was because the principle was. The rain picked up slightly, pattering against metal railings and windbreakers. Kennedy raised the Constitution slightly, not for effect, but as a reminder. This document doesn't guarantee that the powerful will always listen. It doesn't promise that truth will always be comfortable, but it does say something that matters. It says we, the people, do not answer to silence. He looked down briefly, as if gathering something unscripted. I have been called many things over the last week. Obstinate, combative, disruptive. Maybe some of it's true, but I wasn't disruptive because I raised my voice. I was disruptive because I refused to lower it. Someone in the crowd nodded. I was warned, publicly and privately, to back down, to play the part, to keep things civil for the sake of optics. But civil isn't quiet. Civil isn't obedient. Civil is standing firm in a room, designed to make you feel small and saying, with full voice, I will not disappear for your comfort. He let that hang in the rain. A few cameras zoomed in. The raindrops on his shoulders now glistened under the gray light. He continued. They said I disrupted the process, but if a process can't survive a question, maybe the process was never that strong to begin with. He held up the Constitution again, gently. This isn't just ink and parchment. It's a torch, passed from hands more worn than mine, through trials more vicious than this one. And every time someone tries to use power to smother its light, someone else has to carry it through the storm. He looked to the side for a second, then back to the crowd. I didn't come here to be right. I came here to ask a question. And if asking a question is now a punishable offense, then what they're really saying is, he stepped forward, out from under the makeshift cover. They're saying we don't need answers anymore. We don't even need to ask. He opened the Constitution slowly, rain dotting its pages. Well, I disagree. His voice tightened, not louder, just heavier. If they want to punish me for asking, then they're really saying something worse. They're saying we don't deserve answers. They're saying the right to question is now the threat. He closed the book carefully and tucked it under his arm. And if that's where we are now, then we don't have a crisis of civility. He looked into the lens of the nearest camera, steady. We have a crisis of courage. There was no applause, no cheers, just silence. The kind that follows a truth no one wants to hear, but everyone recognizes. Kennedy stepped back from the mic. He didn't linger. He walked down the wet steps without looking back, each footfall soft but certain. And as he disappeared into the waiting car, one image remained. A man alone in the rain, no entourage, no victory lap, just a folded Constitution, and the weight of a question that would not go away. By sundown, that image had gone viral. It wasn't labeled Republican or Democrat. It wasn't framed as a scandal. It was titled with one quiet sentence. He stood when it mattered, and refused to sit down.